As I've mentioned, the spotlight is on former President Jacob Zuma's corruption trial this morning. Zuma faces charges of fraud, corruption and racketeering related to the 1999 arms procurement deal. The matter is set to be heard virtually, but the former president's foundation is against the move. Let us now take you live to those proceedings.
To deliver the unsigned copies along.
That's fine.
Thank you.
If the other parties are happy to proceed on the basis.
Yes, we're also in the last throes of finalizing heads of argument, which we will send in due course. But if I may proceed on the basis, the pleadings as they are, for the sake of progress.
Yes, certainly. Please proceed.
Thank you, my Lord. My Lord, hopefully this should not be a long session. We, as directed by the court after the exchange of emails and so on, filed or delivered an application on Saturday, application for a postponement and a declarator, which basically go together. Now, our attitude, let me start by saying, my Lord, that our attitude, the reason why former President Zuma is present in this portion, because we acknowledge and accept that when it comes to the matter of a postponement, both the Act and the regulations provide for postponements to be done in this manner by audio link. And as it happened, we had consulted with former President Zuma on Thursday, as indicated in our emails, to the effect that there would be a postponement application, because those were the indications that we had at that stage from the bench, and also at least that were indicated acceptance in our own email. Unfortunately, for obvious reasons and the logistical reasons involved in consulting, we have not had another opportunity to consult with former President Zuma. It was difficult enough to get that first consultation, which we had on the 15th, I think, my Lord. Thursday, the 15th, was the consultation which we indicated in the correspondence to your Lordship. And therefore, his presence here is really merely for the consultation, or rather for the postponement application. As your Lordship would have noticed in our application, where we draw the line is when the trial proceedings themselves take place. And we strongly object to any of the trial proceedings being carried out on this platform. And so, depending on the outcome of the postponement application, we would then take instructions as to what needs to be done, if anything. Obviously, if the postponement application is successful, then that's the end of it. But if it is not, then we will have to take instruction. So that's just the broad background, my Lord. Let me then get straight into it. Our starting point, my Lord, is that the proposed mode of hearing of the trial proceedings is in direct breach of the Section 35(3) rights of the applicant in the postponement application. I don't have to convince your Lordship. Your Lordship knows that the Section 35(3), among other things, provides for the following three things. 35(3)(c It says every accused person has a right to a fair trial, which includes the right to a public trial for an ordinary court. The Lordship will also know that 35(3)(e) is that every accused has a right to a fair trial, which includes the right to be present when being tried. And then we add in F, subsection F, which is the right to be represented by a legal practitioner, and I'll explain what the relevance of that one. So it's basically 35(3)(c), E, and F, my lord, that are at play here.
Yes, the affidavits refer to C and E.
Yes, my lord, I'm adding in
Not
F. Yes, it doesn't include F, but it does. If you look at the letter that we wrote, for example, my lord, that spoke about the difficulty in consultation. In our respectful submission, that would include F.
All right, well, we'll hear what the other side say about that later.
But anyway, it doesn't matter. One is enough. One constitutional right, you don't have to have hundreds of them. Yeah, one is violated, it's enough. But we would like to explain the fact that one of the root issues here is the ability to consult, or firstly to have consulted up to now, and also to consult even during those proceedings. As I say, okay, even if you confine it to C and E for now, very few people will have qualms with the fact that the right to a public trial before an ordinary court, and the right, more importantly, the right to be present when being tried, is at stake here. Now, the way we would like to approach it, my lord, is assuming everyone accepts that those rights are limited to some extent by the current process, then the answer will be, is there any legal basis for limiting or violating those rights in the context, in particular, of a criminal trial? Your Lordship will see that we've taken the approach to look at what one might call the possible legal grounds upon which Your Lordship could proceed with the trial proceedings in the absence of the accused person. And we will show, my lord, that none of the grounds which may be relied on apply in this particular case. Your Lordship will know that Section 158(1), which is the first route which could have been used, basically codifies Section 35(3)(e), because that section says, Section 158(1), except as otherwise expressly provided by this Act or any other law, all criminal proceedings in any court shall take place in the presence of the accused. So that there's no debate about that. The presence of the accused is defined later in terms of 159. I'll come to that. But the first exception, my lord, for the 158 right to have the presence of the accused is subsection 2, which says a court may yes, my lord. A court may, subject to Section 153, on its own initiative or on application by the public prosecutor, order that a witness or an accused, if the witness or accused consents thereto, may give evidence by means of a closed-circuit television or similar electronic media. The trigger there is obviously the words, if the witness or accused consents thereto. Now, in this case, the accused certainly does not consent to the trial itself being conducted by closed-circuit television. And as we indicated, he consents, and in any event, the law applies clearly to the question of the postponement application, hence is here. Then, my lord, the subsection 158.3 also deals with what are called the 5 criteria which must be present for subsection 2 to apply. But once subsection 2 is kicked out by the absence of consent, the subsection 3 becomes irrelevant. So that's the first route by which the exception to the presence of the accused could have been based. The second one, of course, my lord, is section 159(1). That one says, if an accused at criminal proceedings conducts himself in a manner which makes the continuance of the proceedings in the presence impracticable, the court may direct that he be removed and that the proceedings continue in his absence. Now, that one self-evidently does not apply here because there's no question of conduct by the accused which causes his exclusion.
Neither of those two have been suggested or relied upon by the state, I think.
Well, those are the only the only point I'm making is that those are the only grounds upon which such a deviation can. And then 159A is the one that brings us here for now. It's the one about postponement of certain criminal proceedings through audiovisual link. I've already said that we accept that that applies to the postponement application. The key there being that it only applies to a postponement application and not to anything else, certainly not to the trial itself. Then, my lord, the only other grounds that are relied upon by the state is the regulations that are promulgated in terms of the Disaster Management Act. And we say there, my lord, well, firstly, the regulations themselves refer specifically also to postponements. So, in a way, the regulations codify the provisions of Section 159 big A.
Okay.
Those regulations are attached to the answering affidavit, my lord.
Yeah. I have them. Thank you.
You've got them, yes. Sorry, my lord. The lordship will see that and I must apologize, the papers are not indexed. But paragraph 8 of the regulations issued by Minister Lamola also say an audio-visual link where such link exists must be used for postponing cases where accused persons are in custody. And as I say, that's simply as a codification of 159A. And then it says number 10, which might also be relevant, an audiovisual link may also be used for a bail application and any other process deemed appropriate by the judicial officer. And then number 11 also deals with postponements and so on. The rest of it does not deal with criminal proceedings. But in any event, my lord, it's a futile exercise. Those regulations could not possibly trump the Section 35(3) rights of an accused person. And there's a reason why even the minister confined this audiovisual link access to issues of postponement and bail applications and the like.